Welcome, everyone. Good afternoon, or for those on the other parts of the country, good morning. I'm David Carter, President and CEO of the E-commerce Innovation Alliance, and welcome to our webinar today, providing an important update on Texas SB 140 in advance of Black Friday and Cyber Monday. I'm joined today by Matt Fitzgerald, a partner with McGuire Woods, and with Elliot Ginsburg, Senior Vice President of Messaging and Legal from Postscript. I'll start, Matt, if you could just introduce yourself a little bit and tell the audience why you're here today.
Sure. Thanks, David. My name is Matt Fitzgerald. I'm a litigation partner at McGuire Woods and one of the heads of the appellate practice here at this firm. And I am here today because I have assisted with the litigation that EIA and Postscript have brought against the Texas Attorney General over SB 140.
Great. Thanks, Matt. Elliot, do you want to do a quick introduction as well?
Sure. So I'm Elliot. I head up legal here at Postscript, working with our 20,000 plus merchants, and also sit in a dual role as the chairman of the EIA, working with David at the beginning to launch this initiative and the EIA more broadly to deal with these issues across the country, and happy to provide some perspective from the in-house side of things and what we've seen and kind of how our customers have handled litigation more broadly in the ecosystem and as that relates to Texas as well.
Excellent. So just a couple of housekeeping matters as we kick off the discussion today. First, please do keep in mind that there are Q&A and chat features on the right side of the screen that you're welcome to use. If you have questions, please use the Q&A feature in particular. We'll try to get to those as time permits towards the end of the discussion today. Do also keep in mind that anything that is shared in the chat and the QA is public information, so please don't include any confidential or sensitive business information in the chat. Also, the opinions and views expressed today are our own, and they don't and are not intended to provide legal advice. So if you have specific follow-up questions for your company, we would encourage you to consult with your own legal counsel. So with that background, we'll go ahead and kick off the discussion today with a quick overview of Texas SB 140. We hosted a webinar about SB 140 now a little over a month and a half ago, where we first talked about the law coming into effect beginning September 1st. And we described that it amended 3 specific chapters of the existing telecommunications and telephone solicitation laws in Texas, most specifically to add text messaging to some of the definitions in those chapters. This was, at the time, considered a pretty significant development across the industry, as a lot of people were interpreting and expressing that the view that Texas SB 140, by adding telephone solicitations and text messaging into the definition, required companies to engage in some pretty onerous processes that we'll talk in length about today, about registration and reporting and disclosure requirements. But where we began the discussion last time, and is sort of where I also want to take the discussion again to kick us off, which is to provide some context about this bill as it worked its way through the Texas legislature. It essentially had 2 lead sponsors, one in the Senate, one in the House. And importantly, throughout the process that the bill worked its way through the legislature, it was clear that these sponsors did not intend to reach communications that were sent with prior consumer consent. So if a consumer was providing consent to your business, signing up to receive your text messages, at least from the view of these sponsors, the bill really had nothing to do with that this was all about unsolicited and unwanted calls and text messages. And they made that clear throughout the course of the process as it worked its way through the legislature. Unfortunately, at the very end of the legislative process, after individuals from the public had their final opportunity to comment on the bill, a substitute piece of legislation was introduced by the chairman of the last committee that injected into it this uncertainty about whether or not the bill actually only reached unwanted and unsolicited text messages, or whether the legislation went farther and required, for example, registration and disclosures for messages, even if they were sent with consent. And Elliot, I think it's fair to say that that uncertainty caused quite a bit of consternation among both customers at PostScript and more broadly in the ecosystem. Do you want to share a little bit about that?
I think you might still be understating it, David. To be frank with you, I know many of you sitting here were dealing with these difficult decisions and questions and getting, frankly, a lot of very conflicting advice out there in the space at the time. I think it's been an area that EIA felt was really the exact mission and reason why the EIA came into existence was to help bring the industry together on issues like this and look to provide clarity so businesses and e-com businesses, particularly going into a busy Q4, can get back to focusing on specifically what it is that they do best, which is marketing, not dealing with litigation or burdensome registration. So I know that there's been a lot of different interpretations of this. I think that is very case in point to exactly what was wrong with how the bill was drafted initially. And we're very happy that I think the work that the EIA has done, and David will get into more here, has helped to bring clarity to that. But we do know that there were a lot of conflicting, there was a lot of conflicting guidance given out throughout the industry.
Great. And so let me just talk a little bit about some of that conflicting guidance that people were receiving in the industry as we were, just a couple of weeks before the law was set to go into effect on September 1st. One of the areas that people were receiving conflicting guidance around was the impact of Texas's quiet hours during which calls or text messages could not be sent. And a lot of people expressed the view that because SB 140 had added text messages into the statute in other places, it seemingly to them followed that these quiet hours, which in particular closed off sending messages on Sunday mornings, were somehow now applicable to all text messages. I think, in our first webinar, we said, and we repeat now, that the Texas quiet hour in Chapter 301 actually was not even amended by SB 140. And so the quiet hour provisions that existed under existing Texas law were not changed or impacted at all by this new bill. And as a result, those quiet hours really only apply to residential telephone calls, not to text messages, and that they remain unaffected by the legislation. And so there's no change to that limited scope of those. A lot of platforms, I think PostScript included, provides options for people to use or expand quiet hours if they want to, out of a matter of courtesy. But in terms from a legal perspective and an interpretation of the statute, it's fairly clear that SB 140 did not make any impact to the quiet hour provisions. The other area that we've kind of alluded to more fully is Chapter 302. And this is really the heart of where the issues arose and where the litigation focused that we'll be talking more about. And under SB 140, what it did is it did include or extend the definition of telephone solicitation to include text, graphics, or image messages, and so bringing SMS into the rules. And the chapter imposes the requirements to register with the Texas Secretary of State, to pay filing fees, to post a bond of $10,000 with the Secretary of State, or you can use other types of security there, like a certificate of deposit, for example. And then it also requires pretty detailed disclosures that have to be included both within the registration form itself, as well as in future text messages to those in Texas. And so this is where, again, a lot of people were having the concern and the consternation about the impact of the law. And we noted at that time that there were a number of exceptions within the law, including a customer exception and a retail establishment exception, that we thought properly extended to cover e-commerce companies sending messages based on consent. But we also recognized that even that was not clearly enough defined in the statute to provide protection. And so we began to think a bit about the landscape and with some of the uncertainties of the statute, and knowing that it could become an area of litigation, we wanted to find a pathway to try to bring greater certainty and clarity to the ecosystem. And so with support from Postscript, we began this conversation and engaged ultimately McGuire Woods and the team that Matthew leads there to help us try to establish that clarity and to pursue the issues with the Secretary of State and the Attorney General in court there in Texas. So let me, before we kind of dive directly into the case and sort of where we are in the litigation, Elliot, you and I have talked quite a bit about some of the impact that companies may have felt if they decided to go ahead and attempt to do the registration process through the Secretary of State's office, and how that advice may ultimately have some negative consequences as well for some of these companies. Do you want to talk through some of those issues?
Sure. First off, I'd like to point out one key aspect of the legislation that I don't think has been brought into the conversation enough, which is, first and foremost, even in a world in which registration is viewed as helpful in defense or otherwise, explicitly stated in the statute is that a brand is not registered and does not receive the safe harbor or a shop, et cetera, sender until the registration is completed. From firsthand experience more broadly across the country, looking at registrations, et cetera, we know that this is not an easy process. It takes time. These offices are under-resourced. We know firsthand in having spoken to shops working with the state in Texas that there's a fairly hefty backlog and these applications are not proceeding quickly. So I did want to call out, regardless of how anyone looks at any of this, the registration is truly when registered, not when applied or filed. But getting into what David was stating,
let's unpack that just a little bit more, Elliot. So talking about, you submit the application and you sit down, you fill out the application, you have your bond, you have your filing fees, and you submit that to the Secretary of State's office. I think what you're saying is that you can't, if you believe you have to register with the Secretary of State, if that's your conclusion, then from the time that you submit the application, or even before that point when you're preparing the application, until the time that the Secretary of State actually gets back to you and says, we've reviewed your application, we have approved the application, we found the application was complete, it had all of the required details. You're saying that if you're registering, then in that period of time, you're not permitted to send text messages to the state of Texas. Is that right?
Yes. That's how I would read things. Yes.
And what I can share with the audience is, as of this week, we have heard from the Secretary of State's office that there are about 600 applications that have been filed based on this interpretation that it extends to text messages. And that, according to them, the vast majority of those applications have not yet been processed by the Secretary of State's office. So those 600 or so companies that have applications currently pending with the Secretary of State are in a weird spot in which they should not be sending text messages to the state of Texas. And it's not clear at this point how long it would take the state to clear that backlog. So this is something that, for those companies that have submitted registrations and are waiting for the Secretary of State's office to act on them, that they could be waiting, for a couple of months if this delay could extend into and through Black Friday, Cyber Monday, for example, for these companies. And in your experience, looking at sort of traffic and volumes and talking to customers, like, what's the business impact of that for these companies?
I think, as many of you know, starting off, we view Texas, in most subscriber lists we look at overall nationally, Texas accounts for anywhere from 9 to 12% of a subscriber list. So if you think about the revenue that brands derive from retarget marketing, particularly going into Q4, which, given the holiday season, Black Friday, Cyber Monday, is a peak time for retargeting existing customers through SMS. You can look at potentially 10% drop off just from not meeting or being able to reach out to and hit those customers. And we've seen many brands, and I've spoken to many GCs, et cetera, along with their CFO counterparts, and looking at truly thinking through what the ROI there and the impact of there. And it's pretty material for brands. And I think that's part of what drove our decision to engage here, and that these brands kind of didn't know which way to go as a result of that, and saw the real trade-off as material to their business going into this prime season.
Great.
I'm happy to come back and speak to your initial piece too, David. I realize I jumped the ball there a bit, but yeah.
Yeah, no, go ahead, Elliot, and continue kind of talking
Sure.
through these pieces.
Getting into the additional pains that brands felt with looking at this actual registration form, which as Postscript and the EIA rolled up our sleeves and got into this and saw brands going through it and received the questions, we really dug in and truly looked line by line at that registration application and filing. And some of the key things we wanted to call out in areas that gave us a lot of pause along with our brands was the requirement, for example, to disclose the personal information and address of the sender. As you know, on a platform like Postscript that has automated texting, et cetera, they can be a little squishy as to who is the sender there. In many cases, though, this could be interpreted, I think, by a creative serial plaintiff's attorney to include anyone who's kind of setting up the messaging inside of a brand, the retention marketer or whatnot. Other information required in the application is details of every single supplier that a brand uses, which we know is often the secret sauce for a lot of shops, particularly against direct competitors. Further, in some instances, the cost of goods sold, that exactly what you are paying to said suppliers on a unit or product line basis would need to be disclosed. And all of this becomes, per the letter of the statute, publicly available. Folks can reach out to the state of Texas and they're required to provide this information, this secret sauce, this invasive personal information about the sender. So we saw many brands really struggling with that, going all the way to the C-suite executives. I had CEOs reaching out to me and being like, can I fill this out and not include this extremely sensitive information, often making a calculation that secret sauce is more valuable than even sending to Texas or their SMS marketing program, et cetera. Those are very important pieces of details for many brands. And as we were going through that analysis, I think it comes back to nothing in the statute says that any of this information is optional. It is generally a fairly binary registration process. You are either including the information and accurately, or you're not. So I do know that there were different theories out there in the space coming forward where some folks were saying, well, I'll just fill out what I can and then skip the parts that I don't want to fill out. I would say that is probably a non-answer, to be frank. I think that frankly solves nothing, while also kind of creating additional complexity and hurdles that we can get into later if there were to be any further analysis of this.
Yeah, and I'm seeing some comments and questions in the chat, which we'll come back to as we kind of move through the discussion. But I think one of the points that is being made by someone in the chat right now is that they submitted a form and the Secretary of State didn't like the way they submitted the form or submitted the payment. And so there's potential that it's being rejected for that. And so for companies that were trying to just register, but at the same time do something to protect this sensitive information, they're probably also in a place in which they may hear from the Secretary of State's office eventually, when they get around to reviewing the application, that it's incomplete or insufficient, and that it could be rejected for those reasons as well. And so really putting companies in a very difficult position about choosing whether to register, what to submit, and then ultimately will they get through the registration process in a timely manner. And then, Elliot, we've also talked about these ongoing disclosure requirements in the text messages themselves that also incorporate some of this information in a way that potentially doubles or triples the cost of sending messages if you did register and try to comply with that requirement.
Exactly. That came up in several conversations. One, calling out this is additional language that can result in a second or third message potentially being sent on every campaign, every message. As the marketers here know, text messaging is not the cheapest outreach channel by any stretch, and it's priced at a carrier AT&T Verizon level on a per segment, per message sent basis. So this materially changes the ROI of the channel, the viability of it in certain circumstances. Or again, kind of the flip side of it is not doing it, but having registered and being in kind of a legal limbo as well. So this created a lot of consternation too.
Great. Let's talk about the lawsuit then. So Matt, I'm going to ask you to jump in here, and if you don't mind, kind of narrate a little bit through the process of filing the litigation, and then ultimately to the response from the Texas Attorney General's office.
Sure. Thanks, David. So on the 1st and 2nd of September, we filed a complaint against the Secretary of State and the Attorney General of Texas, based on the fact that it's the Secretary of State who takes in the registrations, and it's the Attorney General who has enforcement power over this, in addition to private plaintiffs who obviously you can't aggressively sue on the day that the law takes effect. So we sued who we could sue, and in short, we argued that as applied to consent-based text messaging, that Texas's law violates the First Amendment, commercial speech regulation, that essentially people who had consented, and I think it's actually better than consent. I mean, obviously what we're talking about is people who type their phone numbers into a website and click on, a thing that says, yes, I'll take the discount, or text me, I want to hear from you. So people who are getting invited messages like that have a right to get them, and we have a right to send them. And the Texas law violates the First Amendment to the extent it's applied against that portion of the market, which is you guys. So after the complaint, we followed up quickly with a motion for a preliminary injunction, which is just sort of how these cases work. You basically ask the court for a preview ruling of the ultimate merits. Obviously, litigation takes a long time, and we wanted something quickly. So we moved for an injunction, asking the court to prevent the Attorney General from enforcing the law against us. So in response, the Texas Attorney General filed a move to dismiss our case and also opposed our preliminary injunction on overlapping grounds. And I don't want to get too in the weeds here, but basically they argued sovereign immunity, they argued standing, they argued all sorts of things. But the common thread of what they are arguing is that the statute should not be interpreted to include consent-based text messaging, and therefore we're not at any risk of enforcement by the Texas AG. Therefore, there's no breach of the sovereign immunity of the government. Therefore, we don't have any essentially properly viewed. You all do not have a problem under Texas law, and therefore, this lawsuit should go away. So while that all sounds kind of aggressive when I say it, it's actually a good position for them to take. Obviously, they could have said, of course, you're included under the statute and it complies with the First Amendment. I think that would be a hard argument for them to make, but they didn't do that. And so what we're doing now is talking to them about ways we might potentially resolve the lawsuit. I mean, and the challenge for our side is to come up with what we want that they could give us that would give the maximum sort of coverage to PostScript customers and to the industry in general. And so among the things we're discussing with them are the possibility of an attorney general opinion, which would be good. Obviously, it would have meaningful persuasive force, certainly against the AG and to some meaningful extent against private lawsuits as well. And other ideas have been kicked around, putting something perhaps on the Secretary of State's website. All these are our ideas being pitched to them, and we're in the process of talking to them about about how to formalize the position that they have taken so that it is of the maximum use to industry. And the slide here is from the declaration put in by the Texas AG, saying that they understand, even though the word telephone was removed from telephone call, that call means telephone call, which brings in the exception that applies to telephone calls for consent-based contacts.
Great. Yeah. And Matt, this is that exception that they're specifically pointing to, which in the version of the bill before the last minute changes, it was this linkage was quite clear. And so it was clear that all the way through the legislative process, everyone understood and anticipated that this exception for messages being sent with prior consent would be incorporated into Section 302. And really, you know, as I read through the Attorney General's the briefing, and they're like, we get the fact that like you could squint at this and say maybe this exception doesn't get there, but really they were pretty clear in saying to them that that would be a pretty absurd way to interpret the statute, that you had to look at the statute as both its intent and the words that it was using, and that therefore this exception to cover consent-based messages really had to be understood to be there to make the statute work as a whole. Is that a fair characterization?
Yes. And also fits with the purpose of the statute. You know, there isn't any discussion by the legislators that you were mentioning or by anybody else in passing this. I mean, it seems clear that what they meant to do is add texts to telephone calls under the statute, which would, of course, bring in the exceptions that telephone calls already have. The fact that by messing around with the language, they arguably broke that link just doesn't seem to be what they meant to do. And so the Texas AG has been pleasantly strong in terms of how they would interpret this. Yeah. So I see a question is this just an opinion from the AG? Does this leave people open to the civil case? And we can talk about that, David, if we're coming to that. But the short version is what we have gotten so far is a litigation position taken by the Texas AG. So it's persuasive, it's useful in any sort of litigation, but we're trying to formalize it to try to make it even more useful if we can in other litigations. But in terms of its powerful force over civil litigation, like against if a private plaintiff were to sue, I mean, it's a piece of evidence. It's a piece of something you could argue about what the proper way that the law should be interpreted is. It's obviously a public filing in the docket. Anybody can look at it, but we are working to get see if we can get them to say it more clearly and formally, not more clearly, just more formally, so that it would be more applicable.
Great. So we're going to touch base a little bit more on that as well, and here in just a moment. But let's get to, based on where we are currently, what is the advice that EIA has? And our perspective on this is that given the Attorney General's position and the Secretary of State's adoption of that position, that registration is not a requirement, not something that would be enforced by the state, then we are not recommending that people continue with filing registrations if they have not already done so. This is because essentially the state is saying, we don't want your registration forms. So if you're going to go through the process and you're going to continue to register, it must be because you believe that you are required to register and that therefore you're not sending consent-based messages. And once again, as we talked earlier with Elliot, if you're going to file a form, then you have to stop sending messages to Texas until your form and your process is complete. And we know that that could be some period of time. We think that combined with the fact that once you do the registration process, you have these ongoing disclosure requirements and these other areas that they themselves could become a source of litigation if you don't do 100% of the things that are required. We think that on balance, the risk is less to proceed without registration based on the Attorney General's clear guidance here than it is to go through the registration process and take on those burdens. Most e-commerce companies, I would say with few exceptions, are probably not well positioned to meet the burdens and the requirements that come along with the registration process on an ongoing and perpetual basis. And any slip of those requirements could itself become a source of litigation. So we realize it's not necessarily slam dunk in every direction. There's always some trade-offs here, but that on the whole, we think that continuing without registration remains the more balanced approach here, and the one that frankly is more likely to be effective if you ended up actually having some type of litigation that you had to engage with on this process. And Matt, I don't know if you want to speak a little bit about kind of in the context of private litigation. You sort of explained that this would be a piece of evidence that the court could look to. As you sort of think about that, well, maybe I'll make a statement and you can agree or disagree. When I think about that, as someone that litigated for 15 years in these types of cases, I would much rather go into court with the position that we did not have to register. The Attorney General said we didn't have to register. The Secretary of State said we didn't have to register, and therefore I did not file this. And I would rather defend that, because with the clear kind of rationale that the Attorney General provided, I don't see it likely that a court is going to be like, oh, I'm going to find that you have all this unfulfilled liability and this exposure and all these potential damages racking up against your company because you accepted the advice of the Attorney General and didn't register. Like, I just think that that's a pretty hard place for a court to find themselves, versus if you're sort of like half in and you're half registered, but you didn't get it done right, and you've sort of acknowledged or almost conceded that you're bound by the registration process. So I, as a litigator, would rather go in with that clear line than have a muddied picture that I'm trying to paint for the court.
Yes, I agree with that. I mean, obviously, it's an interpretation of a statute. So it's unless there is a formal Attorney General opinion or a formal opinion of a court that can be precedential, this is an argument made by a side in a civil case. It's a pretty good model for the argument that any one of us would make in defending a case like this. And I think it all is also very valuable that the Texas AG is the one who has taken this position and created this model. And it is more reasonable than the other side would be, I think, to say, given this is the position of the Texas AG, this is the right way to interpret the statute. The reason why we're pursuing avenues to hopefully try to get this formalized more in some way is just, I mean, it's sort of down the road, right? The goal is to avoid being sued, not have to fight all the way out to a court's decision ultimately where it agrees with this, or maybe not, but probably agrees with this. You know, that could be after meaningful litigation and expense for your customers and yourselves. Yeah.
So let's talk briefly about kind of next steps as they currently stand in the litigation, just so people are aware of the timeline that we're operating under if the litigation continues, and then we'll circle up to some other follow-up questions as well. Do you want to just talk through this next?
Sure. Step? Yeah. So as we've been negotiating, talking with the Texas Attorney General's office, we've gotten some extended deadlines here, so we have a few more weeks to make our replies. You know, we're hopeful that we won't ever have to do this or go to the hearing or continue the fight, that we'll be able to agree to them doing something better, like perhaps an AG opinion. These are all our ideas, and we are not certainly promising anyone that we will be able to reach that result. It's just our ideas for how this may happen.
Great. So if a preliminary injunction hearing proceeds as currently scheduled with the court on November 13th, when would you anticipate that we would get some resolution of that preliminary injunction motion?
So Usually relatively quickly after the hearing, within a few weeks of the hearing, the court would issue a decision granting or denying the preliminary injunction. Now, this case, because of the way the other side moved to dismiss and oppose the preliminary injunction, it could imaginably be a bit longer than that. But usually this judge is able to move within weeks of a preliminary injunction hearing.
Okay. So, some frequently asked questions, one of which we've already touched on, being about private right of action. Before we move on from that, I don't know, Elliot, if you had thoughts or perspectives that you wanted to share on that issue as well.
An issue near and dear to my heart. I think an important table setting piece here is that if you are sending text messaging, or any brand is sending marketing messaging in the United States, consent-based or otherwise, but particularly hopefully consent-based, litigation, civil shakedowns can and do occur. I think the unfortunate reality of the federal and state landscape is that there are statutory penalties that make it advantageous for entrepreneurial serial plaintiff firms to file hundreds, thousands of demand letters per year. So we refer to these internally kind of as shakedown lawyers, shakedown artists. I'm sure the lawyers on the call here have seen plenty of these. I'm sure, unfortunately, many brands have. It is a reality of the industry that, regardless of Texas, this was happening long before Texas, that these demand letters, these civil suits, these threats of civil suits will occur. I think the important perspective to put this in is that with the updated guidance that we have from the Texas Attorney General, and frankly, EIA and Postscript's reading of the bill from the beginning, is that this Texas law is no different than business as usual before September 1st, when the Texas law went into effect. There will be demand letters. They occur. We don't view Texas as being any more painful, likely to lead to more expensive outcomes, more difficult to resolve in any way, especially with the tools that Matt and David have helped kind of to put on the board. In fact, personal opinion here, I think the tools here against Texas are better than some of the other tools out there against other litigation and shakedown suits that are out there. So it's been a huge push on Postscript's side, and any customers or attorneys of our customers that have talked to me or us here at Postscript is to push back on these suits. What I've seen anecdotally for sure is that brands that are settling and paying out quickly and very reactive to shakedown suits also, first off, end up paying out money, and more money than those that fight. And second, I haven't seen it result in any way in fewer lawsuits coming their way in the future. In fact, again, anecdotally, I've seen several brands not related to Texas, but dealing with the same serial plaintiffs litigants, in which they settled for some 5 or 6 figure number, and then months later they just got hit with another suit because they were seen as not willing to fight, afraid, acquiescent, etc. And it is my strong advice, and the advice of Postscript and the EIA, that to the extent you have strong prior express written consent and you have strong records of this, and you've been meeting the requirements of the guidelines, push back against these these lawsuits, these demand letters, etc. Obviously, in this forum, we can't get into specifics of anything, but I can say, based on our conversations and otherwise, this has been a very fruitful process in talking to CFOs. The ROI has been positive, calculating roughly the value and revenue generated from text messaging broadly versus the cost of fighting these, particularly when working with the EIA or specialized TCPA defense attorneys that can do this very efficiently, that they don't roll over or overreact and advise for costly settlements that just result in more cases, et cetera. So there was a lot there. the key point I would drive home is that in the state that it is now, yes, civil litigation could be filed and they could point to Texas. They could just as easily point to federal TCPA. Quiet hours, which is an entirely different area that I won't get into, but is equally like litigious and shakedown oriented, and also, in our opinion, equally toothless at the end of the day. So yes, civil litigation still available, but far weaker than many of the other risks that are receiving far less attention in the industry now. Yeah, that's all I had on that one.
Yeah, I think, thanks, Elliot. I think to kind of distill that for a couple of points, the threat of civil litigation in the telemarketing and text messaging ecosystem is something that's a constant, right? There's not going to be a silver bullet that means no one will ever get sued on frivolous claims, right? And so when I think about this as a litigator, and I think about how people would be prepared to defend a case under the statute today as compared to just, a month ago, I think the landscape is significantly different. And I think that not only is it different because the Attorney General has agreed with us, but in the strength of their agreement, to the point of them saying that it borderlines or teeters on absurdity, for example, to suggest that this law requires companies sending text messages with consent to register. I think that language in particular stands out to me because it gives the judges a really strong hook to not only potentially go and quickly dismiss a case or move past the case so that the cost of litigation can be contained, but even the potential hook to create the type of decision that could really deter bad actors from continuing to litigate these types of cases. As we work through these issues with the industry, both as in PostScript and through EIA, we are looking for and creating opportunities to significantly reduce the costs of defense for each defendant, such that instead of it kind of everyone going out and choosing their own adventure, so to speak, and picking an attorney that has to then be billed by the hour to come up to speed on these issues and then potentially go down one path or another, what we try to do is we help to standardize the defense process. We help to take some of those costs out of that. And that typically means then having, one or two firms that we highly encourage members and customers to utilize, so that the research and the analysis and the writing and the thinking has already been done for them. And so, to pick an example, you mentioned quiet hours as a case where there's a lot of frivolous litigation. Companies that are getting sued by quiet hours really have two paths they go down in these cases. One of those paths is they work with us, they follow our advice, they go to our recommended outside counsel, and on average, they're spending about $2,500 to get rid of the case and not paying a settlement for that. The other is they choose their own adventure. They go hire an attorney that may know something about TCPA, but hasn't really studied and doesn't deeply understand this issue. And they're probably spending on average $50,000 for the legal advice and still paying on top of that a $15,000 or $20,000 settlement. And so when I think about, again, the landscape and how we shifted, we have, I think, created the right tools in our arsenal now to make this a nuisance, low dollar type issue as compared to the type of issue that requires a significant output of resources over a lot of different companies over an extended period of time. It's something that we can now start to cabin and really push back on in a cost-effective and economical way.
And to David's point, those playbooks, the network of attorneys that the EIA and PostScript have both worked closely with to develop these strategies against lawsuits or dealing with the common lawsuits around the country to make those very low cost to fight and have gotten very strong results in response. Those are available to EIA members and PostScript customers, et cetera. It's part of the value offering here. that we're bringing to the space.
Great. Okay. So does this cover other senders outside of EIA or PostScript? Matt, you're probably the most objective observer here. So how would you take that question?
The litigation itself, no, it covers the parties to the litigation, which obviously is the Texas Attorney General as relevant, and then EIA and PostScript. But as I've said, if we're hopeful that we'll be able to get a Texas Attorney General opinion that would be obviously broadly applicable to everyone in the industry, that would cover everyone. But there is no certainty about whether we'll be able to get that yet.
So a bit of a stay tuned on that one as we continue over the next couple of weeks to try to get to resolution. Obviously, while EIA, PostScript, and our other named plaintiff Flux are kind of leading the charge here, certainly the analysis that the Attorney General provides is analysis that would be broadly applicable to those sending consent-based messages. And so the arguments, I think, would extend even if technically, if we get to a ruling, the ruling itself would not technically extend at that point. So
right.
Great. Let's talk about for those that got advice to just register and they have completed the process or attempted to complete the process, and they're now kind of in the limbo state where they have an application pending. Do you have any advice or thoughts about that situation?
You're asking me?
Anyone, but yeah, we can go down the line and
I mean, I think if you've, and I'm spitballing as much as anybody else here, if you're in the process of trying to register, I don't think you have to complete it. I think if you decide it's not applicable to you, then you could let them know you're deciding not to register, that you're taking the position that that you're not obligated to register, and you want to withdraw your pending application. I mean, I understand there to be quite a backlog there, but I don't see why you couldn't do that.
Yeah, I think that from my perspective, we've asked the question of the Secretary of State's office in terms of what people should do if they don't want to proceed with registration. We have not received a formal response as part of the ongoing discussions on that question. So at this point, my recommendation would be go back to the people who told you to register and ask them to help you get clarity on what to do about the registration process. So if you use outside counsel to get to that conclusion, then you should engage that outside counsel to help you decide whether to unwind it, things of that nature, because until we get some further clarification from the Secretary of State on their advice and the process, which we would share once we get that information, it's a little bit of everyone's guess at this point on how they would handle that type of request to withdraw.
Yeah, I don't have much to add there. I think this is part and parcel with the broader registration analysis, and just an example of why we continue to be against it for those that haven't, in that it's a very complicated process. It's not the cleanest lines of communication on how to handle it. But otherwise, I mirror the advice of the two here who've already spoken to it.
Great. Okay. Well, that concludes kind of the formal discussion today on this topic. Again, as we continue to get new information or guidance from either the Attorney General's office or the Secretary of State, we'll provide and publish updates. And of course, if the case proceeds, we'll publish those decisions or any kind of result that we receive from the court. Thank you to everyone for making time to attend today. If you have further follow-up questions, certainly feel free to reach out by email, and we can try to work to address those separately. But thank you to both Matt and to Elliot for joining us for the conversation today.
Cheers. Thanks all.
David.